Welcome to Protecting Your Legacy with Estate Planning.
Hello and welcome to Protecting Your Legacy with Estate Planning with Adam Grant. Adam is the founding attorney of Stonewood Law Group PC in Encino, California. He helps families across Los Angeles, Orange, Riverside, Ventura, and San Bernardino counties build clear, comprehensive estate plans that protect what matters and help avoid probate. I'm Chelsey, and today we're talking about Heggstad petitions in California, why trust funding issues happen, and what families can do when assets were never properly transferred into a trust. Welcome back, Adam.
Thank you for having me.
Hey, to start, can you explain what a Heggstad petition is and when a family usually discovers that they need one?
It may have a funny name, but Heggstad is the name of a famous case. It follows California Probate Code 850. So we do sometimes call these an 850 petition. A Heggstad petition essentially provides the court guidance on the intent of the testator, the settlor, the trustor, the person who set up the trust, and it guides the court with that intent to provide any assets that may have been missing or not made its way into the trust, instructing the court and the judge to put that asset into the trust. So essentially, if something manages to fall outside of the trust for any one of a million reasons, and there's intent or a proper paper trail that the court can follow, showing that this was the desired outcome, the court will follow that desired outcome and put the property, whether it's an asset or real property, back into the trust.
Someone may have signed a trust years earlier and assumed everything was taken care of. Where do things most commonly break down?
Oftentimes people think that a trust is set and forget, and largely it is if you compare it to things like an LLC, but you do want to keep it updated. That means the assets that are in the trust should remain in the trust. And sometimes what happens, I'll give you an example, is if you do a reverse mortgage or a loan, oftentimes that institution will require that you take the property out of the trust to obtain that loan or that financing. When you get that property out of the trust and you don't put it back in before that person passes away, you have an asset that is outside of the trust. So that's where the set and forget mentality doesn't serve you best. You want to make sure you follow the guidance of the attorney and the instructions that are provided to you, so every asset you do have, especially if it's above the requisite amount, stays within the trust. And that prevents it going through probate or having to do an 850 petition to have it sent back into the trust.
Do these problems show up more often with certain kinds of assets like real estate or investment accounts?
Real estate is where you oftentimes see them. Not to say that it doesn't happen with other accounts, bank accounts, savings accounts, retirement accounts. But often the example I gave you is where you see things happen. People take things out of the trust for financing reasons, or they acquire something outright in their personal name, or it's a joint tenant property. So if you have a bank account and, for instance, it has the trustor and the name of the son, if it's both of those names, it's not a trust asset. So when the trustor passes away, it goes directly to the son. Now, if it didn't have that joint tenancy and it just had that person's name and they had put it in, for instance, their Schedule A, which is an exhibit in the trust that provides for all property that should be held by the trust, the judge, if that's not in the trust, can look at that document, can look at the intent of the trustor and put the property back in the trust so that it can be administered by the trustee.
Great segue. When these cases come up in court, what is the judge actually trying to determine before allowing property into a trust?
So largely what the judge will follow is the intent, the recorded intent of the person who set up the trust. If this was included in their original trust and they took it out for financing or another reason, they can see that the intent was to have it held by the trust, especially if there's additional documentation, like a will where it specifies the same distribution, or if there are papers saying, I intend for this to go to someone. There are a lot of ways you can prove that intent, and that intent will allow the judge to follow what the trustor wanted and put the asset back in the trust for easy administration.
How does a Heggstad petition differ from a full probate case? And why can that difference matter so much for families?
An 850 petition or Heggstad petition can be brought on its own. So it can expedite a probate or a trust administration proceeding in the sense that you don't have to bring a full probate. Now, that said, you might have a probate that needs an 850 petition. So if you're in a probate or a trust administration matter and there are assets that fell outside of the trust, that matter may include an 850 petition to put that property back in the trust. Now, that said, you can do an 850 petition on its own. So presumably the trust has all the other remaining assets in line and can be distributed and just needs this one asset, the real property or bank account, put back in the trust so the trustee can distribute it to the beneficiaries. And that's where the intent of the trustor will help guide the judge to put that asset back in the trust and allow the trustee to easily administer the trust.
What kinds of records or evidence tend to become important when you're trying to show someone intended an asset to be a part of the trust?
So largely the Schedule A is what we would say is a guiding or leading document. This schedule is in the back of the trust. It says what assets are held by the trust or intended to be held by the trust. So that shows the intent of the settlor, the trustor, the person who created the trust to have that asset included as part of the larger estate plan, the trust estate. If that document is missing, what the court can also look at are things like assignments. If you do a comprehensive estate plan with an attorney like ourselves, we would provide additional assignments of your property, your LLC or business interests, your real property, and perhaps, especially with us, a general assignment, which includes things like your intellectual property rights, safety deposit boxes. So it assigns all the catch-all items that we would want assigned to the trust. What that does is, if you get to a point where one of those assets, say a big piece of artwork, is not included, but the general assignment includes all artwork and the papers and relevant artifacts or valuable collectibles, that will instruct the judge to then simply put that item into the trust.
Can you walk through a situation where a family discovered one of these trust funding issues after a loved one passed away and what it took to resolve this?
Yeah, so oftentimes clients don't figure this out until someone has passed away. And then what you have to do is petition the court for an 850 or a Heggstad to bring this property back into the trust. What happens in large part and in reality when you're carrying out the steps of administering a trust is that you're going to find a lot of assets, whether they are trust assets or not. So you'll go through each of the bank accounts, each of the real property, each of the retirement accounts and pension plans, all of the applicable accounts that that owner may have held, and you're going to make sure they're in the trust. If they're in the trust, you can easily administer things privately outside the court purview without your public information going wide. The alternative is that you find out one of these accounts is either held in joint tenancy or outside of the trust in their personal name. And if it's in their personal name, it's an asset you would have to then bring back into the trust so that the trustee can administer that asset with the remainder of the assets.
Are there situations where a Heggstad petition is not an option, even if everyone agrees the asset was supposed to be in the trust?
So yes, there are limits set by the court, but you have to take into reality what is in existence for the court to consider. So the court needs intent. And it can't just be, my brother told me he intended for this real property to be a trust property. That's not sufficient. So the court is going to look to what's recorded. Are there assignments or are there additional documents in the estate plan that support that transfer or that item being held by the trust? Are there additional statements or documents filed by the trustor that support this being a trust asset at some point? That will give the guidance to the court to put this back in the trust. But again, it's not always the right application. So if there isn't intent, there's not the right circumstances to bring this to court. But again, if you have those assignments and a clear record of the trustor's intent, this would be something you should consider.
Looking back, are there certain trust funding mistakes you see over and over that families could realistically avoid with better planning up front?
Absolutely. So this is all preventable. And with a few minutes of planning with your trust and estate attorney, you can make sure that all assets are in the trust or ask questions about acquired assets during your lifetime. But what you want to do is not wait until someone passes away. You want to check with your institutions and make sure the titling is correct, that the real property, for instance, is in the trust or hasn't been taken out of the trust. If it has, put it back in. Looking at the designations on things like 401ks or retirement accounts and making sure that the secondary beneficiary on that account is the trust. So ensuring that all the designations are up to date and accurate, follow or flow through the trust, and doing that regularly with your estate planning attorney will help you avoid this issue. You can have an estate plan that has everything tied up in this trust, and if everything's held by that trust, you avoid probate, which is the ultimate goal of the client.
Thank you for listening to today's episode of Protecting Your Legacy with Estate Planning. If you have questions about trust funding, probate avoidance, or trust administration in California, visit stonewoodlaw.com to learn more about Adam Grant and Stonewood Law Group PC. And don't forget to like, subscribe, and leave a review so more families can find guidance when they need it most.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.